There's a shift in Louisiana law just signed by the governor that could allow first and second offense DWIs to be tried by a jury.
That's a big possible change from the normal process where most first offenders are eligible to enter a diversion program in exchange to have the charges dismissed. Our Ethan Tuttle spoke to a defense attorney and the EBR district attorney about what this means.
HB 403, signed into law by Governor Jeff Landry last month, could make courts a lot busier. An unintended consequence, raising fines for misdemeanor DWIs, which defense lawyers say now makes them eligible to be tried by a jury. Franz Borghardt, a defense lawyer and former prosecutor, is concerned this new law could cause a logjam in the judicial process in a city where the DA's office has voiced it lacks necessary resources.
It is going to create a huge backlog of DWIs, okay? You're not going to see more DWIs, you're just going to see a bottlenecking, if you will, of the current DWIs.
EBR District Attorney Hiller Moore says that while the legislature was going through, he was never made aware of the provision increasing the fines for certain misdemeanor DWIs, which is a key part of the law.
Not to the effect that it would impact a misdemeanor being tried as a Duncan misdemeanor or having the ability of requiring a jury trial. That was never discussed.
A Duncan misdemeanor requires that any misdemeanor over $1,000 is eligible for a jury trial, unless the defendant waives his or her right to a trial by jury. Moore says he wouldn't be surprised if this was a miscalculation by the legislature when it comes to phrasing, in hopes if a special session is called, it can be rectified.
When you have thousands of bills, things can happen, particularly when it's a fee versus a fine. Yeah, I can see it happening.
And it is strictly because of the way the legislature phrased it. By adding a fine in addition to the current fine, up to $1,000, it triggered the statutory requirement for a jury.
Moore says the impact of this new law won't completely disrupt day-to-day operations, but some fear DWIs being triable by jury could open the floodgates, straining an already overburdened district attorney's office. As municipal courts are not equipped to handle jury trials, and many of those misdemeanors typically handled there could have to be transferred to district court.
Putting their heads together, figuring out what is the best way to address the issue. Surely defense lawyers don't want to have a jury trial that they don't have to have. I think that everyone right now is going to catch their breath and just say, what's the best way to handle this and how can we correct it?
Ethan Tuttle, WAFB 9 News.
Some of the lawyers we spoke to today say they expect all of this to end up in court if there is no special session. Now, if that doesn't happen, lawmakers would have to wait until next year to fix it.